the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects, against unreasonable search and seizures, shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized. Basically, what that means is the government can't come and search your house unless they have a warrant that has been reviewed by a judge or a magistrate, that is sworn to by the officer with the specific information that they're looking for and the specific location where they'll be looking. That's pretty specific. And there's a reason for that. Now, I talked to you about the abuses of King James II. And one of the abuses was several grants and promises made of fines and forfeitures before any conviction or judgment against the person against whom the same were levied. And they thought that this was utterly and directly contrary to the known laws and statutes of freedom of the realm. Meaning that you can't take things from people unless you have proper authority to do that. What we learned from the Stamp Act is that they couldn't employ local people to carry out this. It just didn't work. So what the king did, King George sent over his soldiers to carry out the laws of the Stamp Act. But he knew, under the same principle, that they couldn't employ the local people to carry out this act with any amount of success. I'll suggest to you they understood that they wouldn't find any local judge or magistrate to grant warrants either. So what the king did was give, in conjunction with the Quartering Act, the soldiers these things called writs of assistance. And what a writ of assistance was, a general warrant that was both written and issued by the king's agent. It's basically what we call a handwritten warrant. Now, that doesn't mean literally handwritten, although, back in those days, I'm sure they didn't have word processors and computers, so they would have literally been handwritten. But what it means is that they could literally just write on the doorstep, I'm at 12 Oak Street, and I'm coming in your house to look for stamps. With no magistrate review, no probable cause. Simple, basic suspicion. And that's what these writs of assistance were. And James Otis was an attorney during that time, and he took upon the battle of finding the writs of assistance. He called them the worst instruments of arbitrary power, the most destructive of English liberty, and the fundamental principles of law that ever was found in an English law book. I want to point out to you the language, because you guys know what, by now, I love this language thing. So, the worst instrument of arbitrary power. That's some pretty strong language. How about most destructive of English liberty? The underlying principle behind the rationale of Parliament to use the Quartering Act in conjunction with the Stamp Acts and the Townshend Acts and the writs of assistance to enforce them was the safety and security of the nation. You see, we had just come out of the French and Indian Wars. We had amassed great debt. And the king knew he had to get that money back. That was the start of the Stamp Act and the Townshend Acts and all the intolerable acts, was the king's attempt to recoup his money to pay back the countries that helped us in the French and Indian War. You see, he wasn't, we give the king a bad rap, I think. But he comes from a different perspective, right? Because remember, there were royalists and parliamentarians. That stuff never goes away. And the king had to be a royalist. He was the royalty. Believing that he was the surveyor of all, appointed by God to be on the throne, it was his responsibility to maintain the welfare of the people. And because the people didn't have all the information that he had, because he could collect all this intelligent data, and he had the ability to be a central point to disperse the funds and know exactly what the people need, more so than every individual person. He did not understand, really honestly, what he was doing to liberty. And I just say that to be, devil's advocate there, but I think from an honest perspective, we have to believe sometimes people have good intentions and they just don't understand the principles of liberty. And I think you have to understand that when you start bringing these principles to your friends and neighbors. Because your friends and neighbors may have the perspective that the federal government should legitimately be able to choose what's best for us. Not because they as individuals are evil and want to oppress liberty. They're just misinformed. And they lack the very same education that many of us lacked before we started researching and learning. So we're not going to get anywhere by throwing our finger in people's faces and screaming tyranny and oppression. Because remember, we have to engage in legitimate debate. And we do not have to be angry and forceful about it because, number one, we know the truth. And number two, we know that the truth will always defeat a lie. And you don't defeat a lie with volume and emotion. You defeat it with the truth. So understanding that maybe the king wasn't attempting to be evil and oppressive. Maybe he just thought he had a legitimate government interest. And he was astounded at the fact that the people in the Americas didn't understand that. Because remember, some of the argument in Parliament was, you have representation colonies. What are you arguing about? You see, our leaders from the colonies were saying, we need representation in Parliament. Parliament was saying, you have representation. What are you talking about? The argument was the representation was not taken from the people. They had people that were supposed to be representing them in Parliament, but they were not from where they were from. They didn't have their interests at hand, and they were not subject to the laws that they were making against the colonies. So at best, we have a differing of perspectives. And if you want to win over your friends and family and coworkers to the truth, then I think, might I suggest that you approach it from that perspective. We just have a differing of opinions, and we have to battle a misinformation. So what we have here is the king trying to recoup his funds. Parliament saying we have to do this as a matter of national security, because a country in debt is a country that's insecure. How many of you know about the Patriot Act? I have found that even some of the legislators who voted to extend the Patriot Act don't even really understand what it is. I was just in North Carolina, had the honor of teaching 2 North Carolina legislators. And they came up to me and said they want me to come back and teach the whole legislative body what I had taught them, because they didn't know. How many of you would like your legislators to know what you learned today? Well, let me tell you what. They're not ignorant of the principle, to whom much is given, much is required. And I wonder sometimes if maybe they don't want to know because they think they won't be required to live up to it. But that's where we have to come in. That's where we have to inform them. All right. There is a provision in the Patriot Act called the National Security Letters. National Security Letters permit law enforcement, FBI, to obtain records of people not suspected of any wrongdoing without a judge or a magistrate or a court order, not even based on suspicion, but based on the principle of relevance, which is even less than suspicion. To compound that, there's a gag order on these national security letters that says, ladies, if you are served with a national security letter and your husband's not home, if you tell him, you will be arrested and federally prosecuted. Worse yet, if you dispute the validity of a national security letter and you want to consult an attorney, you can't, because that gag order covers attorneys. If you consult with an attorney, you will be arrested and federally prosecuted. You can look at me, Chrisanne, you are crazy. That would not happen in our country. How about in July of 2005, the FBI issued a national security letter to 4 Connecticut librarians for 45 minutes of subscriber data from the library computer, because they thought there may have been terrorist communication. Not a threat. Communication. May have been. These librarians understood the Fourth Amendment, I believe, and went straight to their boss and were arrested and federally prosecuted. Taken all the way to a federal jury trial. Being involved in a federal trial, I can tell you that did not happen quickly. And would have been federally prosecuted all the way to the end had the judge said, "Not in my courtroom." Well, the ACLU picks up this case and says this is ridiculous. We cannot have these provisions. And as much as, what we think about the ACLU, At times, quite often, they are defenders of the Constitution. And they achieved what everybody thought was a certain victory. The court ruled that the provisions in the national security letters that contained the gag order and that contained the position where you did not have to have a magistrate were unconstitutional. But, much like the repeal of the Stamp Act, while the people were rejoicing and establishing their statue in honor of King George in New York, the drafters of the Patriot Act went back and created loopholes and said, okay, we will abide by the court, except if the library makes available public internet access. Now I ask you, if this can apply to a library with public internet access, what would limit that from applying to your business who has wireless internet? Loophole number one. Okay, we will not allow the enforcement of the gag order unless it would harm national security. Guess who gets to make that determination? There's a provision called suspicious activity reports, where the federal government can seize bank records based on mere relevance. The point that I want to make here, ladies and gentlemen, is that the national security letters are not limited to foreign terrorists. They apply to U.S. citizens. 2 million bank records have been seized. 2 million here have been seized. 200,000 national security letters have been issued. In 2006, 60% of the 49,000 national security letters were issued against U.S. citizens and legal aliens. Are we to believe that 60% of the terrorist threat in this nation comes from U.S. citizen and legal aliens? What in heaven's name would make us agree to hand over our Fourth Amendment right in the interest of national security? But George Bush was behind it. Well, you know what? We got to stop looking at men and start looking at principles. George Bush was not a conservative. He was a moderate at best. And even Abraham Lincoln traded our constitutional right for national security when he repealed habeas corpus during the Civil War. Why did they take it from us? We gave it. We gave it. How much objection did you see in the body of people over these national security letters? My goodness, it's just been weeks since this very library provision was extended another 90 days. Weeks. By many of the same people that ran and were supported by Tea Party people. When I called my representative and asked him, why did you vote for this? Of course, I spoke to his aide, not to him. He said, well, we didn't actually vote in favor of it. we voted in favor of extending it because we had to see it to see what was in it. And I said, that's strangely like Miss Pelosi's statement. How do you justify that? And I asked him, do you know what a writ of assistance is? No, ma'am, I don't. I said, well, you need to. I said, do you know what a national security letter is? He says, yes, ma'am. I said, do you think they're constitutionally sound? He said, well, they must be. I said, no, sir, they're not. You need to find out. He says, well, I'm not a constitutional attorney. I said, well, funny thing is, I am. But I don't think you need to be. Because everything that I've just told you is available. Free public access on the internet. As a matter of fact, Rand Paul wrote a letter explaining writs of assistance and national security letters. Before he wrote that letter, I wrote an article here in a Florida database called booguy.net that explained writs of assistance and national security letters. Not because I'm a constitutional attorney. My goodness, I only did that for 2 years. Anybody would tell you that does not make me an authority. But because I took the time to know. Because I heard something that said, that's not right. That's not right. 49,000 national security letters in 2006. All in the name of national security. How many of you have heard of H.R. 1955, the Violent Radicalization and Homegrown Terrorist Act? In 2007, the House passed this bill with only 6 opposing votes. Clearly bipartisan passing, 6 opposing votes. Full passage of this act would have opened the door for citizens of the United States to be prosecuted not for actions that they had taken, but also for associating themselves with certain groups possessing certain belief systems. Being associated with certain groups that could, in the future, be interpreted to have violent tendencies. Do you want that mutable definition of terrorist to dictate how the national security letters are enforced? My goodness, we've got the Department of Homeland Security director saying that the greatest threat to national security are Tea Party people and veterans coming back from the Iraq War. In the name of safety and security, our Constitution is being shredded, and our children's futures are in the balance. We can no longer be in the position where simply because we like somebody that we let them get away with everything. A lot of people supported the Patriot Act because it had a sunshine provision, which meant that it was supposed to expire at the same time George Bush would leave office. But they voted to extend it 3 years. The very same politicians who were jumping up and down and vehemently opposing the Patriot Act because it was under George Bush were the ones that voted to extend it for 3 more years under Barack Obama. Benjamin Franklin told us, anyone who would trade liberty for security deserves neither liberty nor security. There is no reason that I can even conceive in my feeble mind that would justify any relaxing of my civil liberties or yours in the name of national security. What we need to understand is what I've been telling you. When you hand over a right because the person you're handing it to is someone you like, they're going to pass it over to the next one that takes over after them. And it may not be someone you like. It is the government's nature to rule and regulate. It has been since the formation of governments. And they do not let go of power. My goodness, income tax was supposed to be temporary. Income tax was supposed to be temporary. How are we to believe that anything will be temporary? It seems to me, once again, that the only people ignorant of our history is the general population. Those that would want to take our liberties, to talk us into handing them over, are intimately familiar with their history. Otherwise, we would not have something like a national security letter that looks exactly like a writ of assistance. Not only that, they must know we're ignorant. Because they're so similar in nature, if we knew our history, we'd have seen it right away and said, whoa! Not on my watch. Not on my watch.